Well, tomorrow we could have a verdict in a lawsuit against the Greenville County Sheriff's Office. Stephon Hopkins alleges deputy used excessive force on him during a foot chase 4 years ago. And you're seeing some body camera footage from what happened. Both sides have now rested their case.
We've been in court all week. Fox Carolina's Grace Runkle brings us the key points from the defense's last witnesses.
Both sides have rested their case in Hopkins versus the Greenville County Sheriff's Office. On the last day of testimony, the defense honed in on Stephon Hopkins' injuries, or as they argue, the lack thereof.
Do you have an opinion to a reasonable degree of medical certainty whether the injuries identified in those records of Mr. Hopkins are consistent with a strike to the face using handcuffs as brass knuckles?
In my opinion, that is not consistent with, these injuries are not consistent with that scenario.
On April 22, 2019, plaintiff Stephon Hopkins says a Greenville County deputy hit him multiple times with handcuffs during a foot chase after the deputy's body camera fell off. Forensic pathologist Dr. Michael Ward says the injuries to Hopkins' face were too broad and the cut too shallow. Ward says the injuries match Deputy Jacob Walter's story, that he punched Hopkins once and without handcuffs. Ward says he reviewed photos and medical records of Hopkins, but plaintiff's attorney, Bakari Sellers, says that wasn't thorough enough. But the bigger issue, Sellers says, is how Ward got Hopkins' medical records in the first place. Hopkins signed a release on March 15, 2021, but Ward looked at those files on March 4th.
As a physician at Greenville Memorial Hospital, licensed to and encourage, allowed, I have access to medical records.
Just because you have access to it doesn't mean you can go in someone's private medical records, because if that were the case, why would Greenville County need a confidential release form for you to access those records?
That is correct.
Is that appropriate, ethically, soundly, to do that without permission, subpoena, or a release from my client?
No, it's not.
Sellers made a motion to strike the doctor's testimony. The judge says that he won't rule in favor of that just yet. Right now, he says the plaintiff's attorneys have the opportunity to attack the doctor's credibility during closing arguments. We expect those to happen first thing Friday morning. In Greenville, Grace Runkle, Fox Carolina News.